Abom ana esibu so breaking news a free court of appeal by say Madam Sedina Tamakloe, former CEO of MASLOC, court no acquitted a discharge no. Na so nko fi mfa ne huni. Very interesting ruling. The 98 pages. You exclusively what was in the appeal. Why is the court and all the three justices? Almost say if you say wa saribotwe a sentence said Sedina Tamakloe no evidence ni more ha. Three justices of the Court of Appeal acquitted and discharged. They be a mirror, me catch you say, yeah, the Yamra, ya report to Emran the bosom of the judges. We hanan the Hremo, Mubufuya, Winswaba. Na, interesting. I'll break it down for you. To make sure you subscribe, mama. Subscribe and click the notification. The video be to my you will certainly have a comment. Feel free, leave that comment in the comment section. We are make sure so be GoldBerry construction limited other episodes in Wasasen Kratasem, the documentations related to your house, you know, GoldBerry. ABD sage money na at the amount. Yanko into the matter. Who is Sedina Tamakloe? A former MASLOC CEO. Na Ebren PP Bass in the 2017 Oma Yoku Ekwache no more prosecutor no or survey from MASLOC 2013 to 2016. And Oma accusing for 78 count be stealing, conspiracy to cause financial loss to the state, conspiracy to steal, briefly causing financial loss to the state, causing loss to public property, money laundering, any idea. Charges ne ba kuni say about tampa microfinance loan prosecution allege Yera Godfrey Damene and in the legal team say Sikebi na ye MASLOC dia 500,000 Ghana cedis. Maame no diabetes sika no. Kono an personal account odiye. Sensitization program na so koye 1.7 million. Wa sensitization am koye baby kitu ni nyina o manye. Na sika no so ejira nkwanta. Another charge almost on the bond is a countermand to fire victims in the Sikebi so do what it is can mani bi kura nya bi any adenes canon so efom kwanta. Again procurement issues and all kotoka na car na 5 CD no ma control 8 CDs say phone na 1 CD no ma control 3 CD and no ye no so sa no so procurement issue a omode ebo no na some ne call court no ana justice efia say wa saribotwe ne dey make us buy interview Lawe FM no a sentence maame to 10 years in jail na no nko na branch friend Daniel Azim ne nansia no nya be ndisi ba ya eno nya be so mo ka Daniel Azim no aha enam ka man for predict say maame abom bi ja no bi ja ne ade no na maame no 2017 wa ana call court kaka say oh o medical issue ni family issue kaka to be so kwabuche no ba no de no kan wura almost 10 years ye hu maame no na January mo ene ye che no enti no on the 9th of June 2026 ana US the Justice Department at the bar said justice has no boundaries. The United States has extradited Sedina Tamakloe Attionu to Ghana following a conviction on 70 plus corruption related charges and including embezzlement more than 6 million cedis equivalent in Ghanaian taxpayers' funds. This is our strong US-Ghana law enforcement partnership in action, demonstrating a shared commitment to accountability and the first extradition from the United States to Ghana since 2000. So that's significant. It tells you that it's a very significant that US crowd who say Adi aye extradited from US to Ghana in almost what 17 years. Near be ye na say US crowd no dwen say charge ne ne mo hu ye ne onyina so ma wo. No de said in a buy. But then your committee said in Tamakloe no we indicated so be file appeal. And on the dynasm na file appeal in 2024. But the written statement no e buy e bra ye che na ye de ne ba Ghana. Now after 78 charge mabam mo call Supreme Court no the grounds of appeal no any one, almost say the conviction and the sentence of the first accused for the offenses of conspiracy to stealing, conspiracy to cause financial loss to the state, causing financial loss to the state, causing loss to public property, improper payment of public funds, unauthorized commitment to resulting in financial obligations to government, money laundering, the breach of Procurement Act is unreasonable and cannot be supported having regard to the evidence on record. Almost share evidence now record na mame efia botwe edigina so sentence na nyansa bi enim na yenkan hu se odwane yenti no state ni kwa ne prove indicate be nye state no so fom so enti Madam Sedina Tamakloe try an ikosu na no wantimi an witness wantimi an defend ko odwane enti state ni ne bo ni nkura. So the conviction of Sedina Tamakloe no by justice efia se wa saribotwe was based on the prosecution fact and witnesses or more the buyer because one party so on in criminal trials or no to defending no or no so fair witnesses or bet you cry interrogate witnesses not stating in the abano we done. So that opportunity was not available to Sedina Tamakloe, and that is not the fault of us. Because us at the state, and yeah fault because we na jana una don't care. So that is not the fault of us. Let's see. Now almost a first ground to say charge near the board no nyansanim, especially procurement issues, causing financial loss to the state in ade. Oti we yasi abete nyamebe ni nyina ase. And course the court below erred in convicting the first and second accused for conspiracy to steal and stealing. The court below erred in convicting the first accused and appellant for conspiracy to causing financial loss to the, as well as financial loss to the state. The court below erred in convicting the first accused and the second accused for causing financial loss. Now, the court need bumra be so. Now, why are they saying court need bumra be so? And only or say the submission intra based on law and evidence demonstrated there was no need for the appellant to open a defense since the prosecution failed to establish the prima facie against the appellant at the close of the prosecution's case. Any subsequent alleged incriminatory evidence or the failure by the appellant to open a defense did not in any way regularize the failure by the prosecution to establish a prima facie case to warrant the appellant to open a defense. After all, it is not the duty of the appellant as accused to prove her innocence. No mo ka say odwane yo wanjane o ene de amfa ye hu debi the basic is that in criminal prosecution the prosecution must prove the case beyond reasonable doubt, but evidence or just when prove the case beyond reasonable doubt, it is the Sedina Tamakloe how and only how o case meant me prove it wa me be the difference kran enye bibia but odwane ye no so nkyere say mun kansem ngu ni so na no monka say my establishing mbrem ne kan prima facie ko prima facie bi eni wa mo adu sie Sedina Tamakloe na ka say ana mo call so ka say in the case of Donko versus the state, the Supreme Court held that there was a miscarriage of justice when the appellant opened his defense, which subsequently led to his conviction, even though at the close of prosecution's case, they failed to establish a prima facie case. To see case be the Supreme Court case. So obi ni wa eno nkyere someone say dem mu asem ngu ne so a miscarriage of justice. And of course case. Your lordships, grounds B and H will be subsumed in ground A for the purpose of other submissions. Or say, the conviction and sentencing of the first accused, Sedina Tamakloe, for the offense of conspiracy to steal, conspiracy to cause financial loss to the states, causing financial loss to the states, causing loss to public property, improper payment of public funds, unauthorized comment of blah blah blah, it's unreasonable and cannot be supported by having regards to the evidence on record. It goes further to read, respectfully, my lords, we have the firm view that the charge sheet which indicated the criminal initiated the criminal proceeding against the appellant cannot form the basis for the prosecution of the appellant. Our contention is anchored on the fact that omobo account in which border on conspiracy to willfully cause financial loss to the state and causing financial loss to the state are defective in the sense that all the charges do not comply with Article 19(2)(d) of the 1992 Constitution, the Criminal and Other Offences Act. Now, yanko Article 19(2)(d) no. Yanko so. 19(2)(d). What is there? Let's read Article 19(2)(d). Or say, a person charged with criminal offense shall be given a fair hearing with a reasonable time by a court. B. A person charged a criminal offense shall, where the punishment is death, the verdict of the jury shall be unanimous. Okay, Maminko B. In the case of an offense triable by original trial, the penalty for it is death. The decision W 19(2)(b), 19(2)(d). Okay, D. Okay, a person charged with a criminal offense shall be informed immediately in the language he understands and in detail of the nature of the offenses charged. And you almost say, Madam Sedina Tamakloe, based on Article 19(2)(d), no, sa embrayi, omujina so ede ya piwa eyi. Later almost say the impugned count do not have detailed particulars informing the appellant of the nature of the offenses the appellant was charged with. No more so again, they come back to attaching and raising to mission. So I define terms and idea no, and no more can one some. And for instance, the prosecution alleged that the appellant dishonestly appropriated monies, but fails to provide details in the particular of what act or omission that constitute the dishonest appropriation. Similarly, the particulars of the offense in count 67 and 69 lack detailed information. The appellant is accused of causing financial loss to public property, but there again, the appellant do not disclose or act or omission of the appellant that allegedly led to the loss of public property, just like count 36 and 66 and count 67 and 69. The particulars do not disclose the nature of the transaction that resulted in the loss of public property. Most wa cause financial loss to property. Munchra de kotsenya wa charge ni munti amoso wa cause loss to public property no. Almost say in count 70 and 71, Sedina Tamakloe is said to have made improper payment of public funds, which are not been verified in line with existing procedures. In the particulars of offense, the prosecution failed to provide detailed information on those alleged existing procedures, which Sedina Tamakloe failed to comply with. Again, most of the procurement measures, procurement ban in document among the bar court meant me and or say then in count 72, the appellant is said to have committed the government of Ghana to a financial obligation without authorization. Again, the particulars of offense in this impugned charge do not disclose which transaction with whom the appellant committed the government of Ghana to and formed the authorization ought to have taken. And almost say, Samusi ni pane bumraswa, emra ben patpoten na wabuso. Mose wako sign Ghana ti edi akose contract bi aso. Ama contract na beda aban so. Contract ben manchirim. Eno mo call so anom there. No na judge no 3. Etina asem no so. Let me get to the names of the justices. Omo tina asem no so no omo say omo ne court no, omo ne prosecution no. Me say prosecution. Omo ne defense team no eya adwen. Enti Justice Emmanuel Senyo Amedeha, Justice Samuel Obindiewu, Justice Emmanuel Ankama, omo so omo ne yura Madam Sedina Tamakloe say adwen. Ocho omo basam na to agu acquitted and discharged. There is no evidence a chiresa maame no edi boni bia. The prosecution couldn't prove their case. So that is why she has been acquitted and discharged. Full ruling, you know, 98 pages. Some the beba in the year and on that so mama evidence to that. I'm very, very, very surprised. But it's a 3-0 decision. So it means that all 3 justices of the court disagrees with one judge at the High Court. I find it very interesting because when you look at the other circumstances, which is not the law, the circumstances, if you knew all these things, if you knew the charges against you, well, yeah, why did she has come? It may not be law, but it's a reasonable question to answer or to ask. If you knew all these things brought against you, charged against you, didn't support the fact of the case, any idea, why did she run away for almost 10 years? That's a legitimate question for everybody to answer. But it is not for the judges to answer that. They will look at the law, whether indeed the prosecution evidence met the threshold of a prima facie determination. I am very, very surprised by this ruling. And to judges, I always tell, let's disagree with judges. Hanan, I disagree with the judge. But I mean to the but I'm very, very surprised that this woman will be acquitted and discharged. I am very, 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 very surprised. But you can say whatever that you want to say. At the end of the day, it is at the bosom of the judge who will determine the matter. Who will determine the matter. I am very, very, very surprised. Exceeding. It's not even a 2-1 decision. It's a 3-0 decision. When the full ruling can the 98 pages, we'll go through book by book by book, page by page, and understand it. I'm very surprised. I'm very surprised. And you see, the political capital, the NPP will enjoy it. Because if you have no buy class and you jail, look at shenanigans. It took several days and suddenly didn't go jail. Now everything is as if, you see, and that is one side I always wish the court, but you see, they are to go as a wound media. Oh, me, I send them 15, about 15 to 25. See, that German 28 years, but sometimes the perception beyond the ruling is important. And the NDC, unfortunately, will have to suffer the consequences of that. Because many people predicted what is happening now. It may not be the law. The judges may not have faulted the law because I've not read the ruling. So on what grounds would I say that I almost timorano? You can't really, I'm only saying that no matter the ruling, me, I'm surprised. And I find it interesting. Surprised and interesting doesn't mean they are wrong. But my shock is that all three disagreed if you say what's a rebuttal. All three. That is what I usually say to find interesting. That is not supposed to mean that I know better than them. I don't know. But we have the right to critique them fairly without necessarily casting aspersions at them and all that. Because in fact, most of these judges were not appointed by the NDC, by the way. So if you want to bring in that element too, that is that. So I'm only saying that I usually say to say a three. I'm surprised. It's just like a Supreme Court ruling, the 5-2 on the two major landmarks. I'm very, very surprised. I'll tell you how I'm surprised. And even Oliver Bakabomo, when other lawyers Kodopumpuni CD, the Omunya said they were surprised. So we are entitled to have to express our surprise at the ruling. I'm very, very surprised by the ruling. Honestly. When I was driving home and I was talking to colleagues in the court, I was like, wow, Eugene, a 3. Because I wanted to confirm whether a 3 or a 2-1. And it's acquitted and discharged. I'm very surprised. And yeah, then this will have to suffer the consequences. People predicted what is happening. And unfortunately, it has gone that way. It will seem as if, unfortunately, you cannot discount that because the MPP time, certain judges, people deem this as that. So you cannot force people for doing that. But unfortunately, it has happened and they have to suffer the consequences of it. I'm surprised. I don't know whether you are surprised or not. But I'm surprised by so some kind hey, interesting. Me view no also view the share your video comments that you are not subscriber. Most subscriber no click the notification. The video be at to be who not match be. Make sure so be show see them me here on Ghana so here. Bye bye.